say, even if they didn't have one on file or never took one, if they were acting in the capacity of an officer, it's detailed in this, they give them de facto standing, which trumps your argument here today. That's your bigger problem. The biggest problem you have today is the appellate courts have addressed these issues in the past and said, if he's a licensed peace officer, got a T-close license, and he's acting in the capacity of a police officer, basically wearing a uniform. Now, those cases come about on where people were assaulting police officers or something to do with whether or not the cop is a cop. The appellate courts have been pretty consistent on the fact that they're cops, regardless of whether they've been legally appointed. There's a couple of cases I know from the past, because I actually researched it for you and I probably 2 or 3 years ago, where they said they don't have to have the oath of office on file, because this is an exception, you understand. It's not to say that it's the law.
The oath of office is a little different, though, I would think.
Well, but the fact is, what the law says is, if it's a procedural defect, if it's a ministerial defect, you get into public policy arguments. There's case law on the fact that if it's a public policy argument, they say, we're not going to allow a failure in some sort of paperwork to disqualify a police officer from being a police officer. Hence, you get the de facto. And what that does is it says, if they're not going to make, you know as well as I do, I'm a stickler on oaths of office also. But the appellate courts have said they don't have to have an oath of office on file. If that's the case, then surely they can do the other.
Well, can I throw out something? Just it's kind of similar. If I were to accept that law book over there and get paid $300 an hour to represent somebody, even though I don't have a law license, and I'm in front of you as a judge, does that make me a de facto lawyer, and can I practice law?
Well, if you are an attorney, if you're an attorney and you've been licensed and you passed the bar, and then say for some reason you did not file your oath of office, or you don't have your what is that other part? The bribery portion of it. You don't have that on file. Guess what the appellate courts have said? They're de facto attorneys, and you're not going to dismiss the case or overturn it because of the fact that there was some ministerial error. In other words, they didn't get a piece of paper filed. They didn't get something filed on time. So where does this wind up leaving you is that it puts you in a spot where, he's a cop. He may not have had, number one, you can't prove here tonight, or you haven't yet, that he has to have approval from the city council to get that done. So that's your part. This, of course, is hearsay. It's inadmissible. But even if it were admissible, there would still be problems with where it came from and whether or not he's even qualified. And then if we did admit it, Mr. Stout would make objections to his qualifications. So
regardless if the officer was illegally appointed, he can go out and write as many tickets as he wants, and that doesn't matter because he's a de facto police officer. That doesn't mean...
No. Number one, you haven't established that he's illegally appointed. And so you can't say he's illegally appointed. You can believe that he is, but you have to prove that he is. And even if there's a difference between he's not illegally appointed. Your argument is he's not appointed.
My argument is he was illegally.
Well, you said he wasn't appointed.
Illegally appointed is what I agree 100%. He's got a badge, he's licensed with T-close. The way he is now working, it wasn't an illegal appointment because the city council did not approve any officer underneath Chief Spurgeon at all. And that is from the city councilwoman herself. That's from the mayor, who unfortunately is not alive anymore, but that was even from him. In public, in a public statement.
I don't have that. I'm not saying that that's...
So even that's hearsay?
That gets us to the case. That gets us right to the case.
Okay.
I mean, the question here is, you don't have a defense that your inspection sticker was good and you were issued a citation for a bad inspection sticker when it was okay. Your argument is he didn't have the authority to stop you and sign the complaint. And you do understand also under Texas law that he doesn't even have to be a police officer to sign a complaint against you.